All right, thank you very much, Oyemi Ajayi, for that backgrounder. With us here in the studios, I would like to welcome to our Abuja studios. Last time we had a conversation, you joined us from our Just Network Center. I'm talking here about learned senior advocate of Nigeria, that's Professor Dakas C.J. Dakas. He's the former Attorney General of Plateau State, and he was the lead consultant to the House of Reps Special Committee on the review of the Constitution. Professor Dakas, glad to have you this morning.
Thank you very much. My pleasure.
Also here with us in the studios is a former Speaker of the Kogi State House of Assembly, Right Honorable Bello Abdullahi. Honorable Abdullahi, morning and welcome.
Thank you, Nigerians. Thank you for inviting me for this program.
Also joining us from our Port Harcourt studio is constitutional lawyer Festus Oguche. Mr. Festus Oguche, I'm sure you're there. All right, thank you for joining us and good morning, Nigeria.
Yes, I'm here. Thank you very much. Good morning, everybody.
All right. Well, gentlemen, we have to apologize that the panel doesn't look quite gender sensitive, but of course this is an ongoing conversation, and therefore the appropriate time we will invite our female compatriots join us in taking a look at this. Now, it seems as if Mr. President quietly gave his assent to 16 of the 35 bills seeking to alter the Constitution for the 5th time. I say quietly because this was on the eve of the governorship elections, and everyone's attention was focused on the governorship and state houses of assembly election. So when the president first signed it, nobody seemed to bother. I mean, people were just concerned about the threats and the issues around the governorship election. But all of that is over. Those who won the elections have received or are receiving their certificates of return. So we get back now to the brass tacks of the reality. Of course, once the President accent is gazetted, we have the reality of 16 amendments to the Constitution as a 5th set. Let's begin with Professor Dakas, who served as a consultant to the House of Reps on this amendment. What is your take on, if you like, this rather sweeping set of amendments that we've had? Probably in terms of just numbers, this is probably one set that is larger than what we have had since the process began with the first alteration. Prof.
Thank you very much. And as you rightly pointed out, I had the privilege of serving as the lead consultant to the House of Representatives Special Committee on Constitution Review. And I'm a constitutional lawyer as well as an international lawyer. And the privilege of serving in that capacity actually provided me rare insights into the manner in which our constitutions have been amended over the course of time, and the lessons that we can learn from that. And one of the things that you have alluded to, which is the sheer number, let's put that in context. At the end of the exercise at the level of the National Assembly, out of the several proposals that were received, as a matter of fact, 44 were passed by the National Assembly and transmitted to the states. Now, the Constitution provides that you need the concurrence of 24 houses of assembly. That's 2/3 of the houses of assembly in respect of every bill for constitutional alteration that is passed by the National Assembly. And so 44 were transmitted to the state houses of assembly. Now, 35 are the ones that received the necessary concurrence. That means that we still have a number of bills that are still pending at the level of the state houses of assembly. Now, out of the 35 that came back, Mr. President ascended to 16. So 19, Mr. President essentially vetoed. Now, so in terms of the sheer number, I think it's a significant development. But I think that more profoundly would be a conversation around the significance of the bills themselves in terms of what they seek to accomplish. And if you look at as the background report pointed out, there are some very fundamental bills on the subject of devolution of powers. And remember that there has been hue and cry over the fact that in our federal system, the powers are skewed in favor of the federal government. So when you look at this in the context of devolution of powers, first, the fact that railways, correctional services, previously known as the prisons, the states have also been empowered to legislate on the generation, distribution, and transmission of power. And that's also a very significant part of that in the context of devolution. So these three, from the exclusive list to the concurrent list. There was one other item of devolution that at this point, apparently the states have not probably taken a decision, and that's the subject of airports. Airports was also supposed to move from the exclusive list to the concurrent list. But two other significant bills that have been assented to by Mr. President on the subject of having to enhance our federalism are the bills on enhanced financial autonomy for the state legislature and the state judiciary. So it's significant not just in terms of the number, but also in terms of the quality of the bills that have been assented to. There are several other issues in respect of which some of us would have loved profound action, but I hope that over the course of the conversation we can explore those ones.
All right. Many thanks, Prof, for that opener to the discussion this morning. Honorable Bello Abdullahi, I remember the last time you were here, we're talking about financial autonomy for houses of assembly. I remember vividly. Yeah, that was the last time you came here. And now looking at what has happened, you know, the 16 alterations that has been assented to by the president, and that being one of it. What's your own impression about what the president has done?
I think, thank you very much. I think what the president has done is a progressive approach to good governance by assenting to these 16 bills, especially as it relates to having financial autonomy to the state houses of assembly. But however, we still have some issues to contend with, even with the autonomy being granted the state assembly. What do I mean? The quality of those at the various state house assembly matters in implementing our laws, and that is one of the biggest challenges that I believe that we'll be facing with this authorization that has been given the state assembly in the area of financial autonomy.
Well, we'll come to that issue presently, Honorable Bello Abdullahi. But let's go over to our Port Harcourt studios, where we earlier introduced a regular on Good Morning Nigeria, Festus Oguche. Festus Oguche, a chief, of course, and also a constitutional lawyer. Chief Oguche, are we step by step getting closer to restructuring for which there has been tremendous clamor?
Fantastic question. It is very, very clear that the president has made a very impressive move towards assenting to these bills and giving a head-on approval to them. And it's quite a very impressive move, I'll say. First of all, I want to point out that it appears our own democratic system is intolerant of referenda. Some argue it is not part of the process, but I think democracy itself pertains to the people's will and popular sovereignty, and I guess that even though it is not clearly spelled out in the Constitution, a referendum is very necessary in these parts as to confer whatever the president is doing, whatever the National Assembly Assembly is doing with some shade of legitimacy. I know of some constitutions like in Australia where there's no clearly spelled out procedure for constitutional amendment, but then they still have recourse to the issue of referendum. Anyway, that's by the way. The action of the president is symptomatic of a direct democratic symptom that will enable the country to move forward and our constitutional license to be improved greatly. I would not say that some of these approvals are sent by the president will be interpreted or translates to devolution of powers, the much sought about devolution of powers, or maybe the elevation of the federal structural arrangement that should be under the system of federalism. You know, but it has its functional implications, I know. There's still very much need to unbundle the national, or rather unbundle the National Assembly of all the lists included in the exclusive legislative list. And this is one good attempt, but it's not very, very much. I wouldn't say that it will also pass for, like I said, for devolution of powers, or probably that maybe we may have to swave the need for a new constitution making. The process is quite cumbersome, but I guess that a lot of these amendments are very, very important, and even though it does not pertain to maybe bringing out a constitution that will be the direct function of the will of the people, it is still accepted that probably there's a move towards that direction. First of all, we are operating a constitutional system that Professor Isawa Ilaigu called unitary federalism. That's a very strange coinage, because we have powers, so much powers are allocated to the center, you know, and that apparently explains why all these people, or everybody's rushing to have some grab at it at the center. But then the component units themselves are areas of strength and areas of where governance should be properly targeted at least to achieving a particular sense of purpose which we all desire. And the amendments, the approvals the president brought are just like scratching it on the surface yet. The learned professors, learned sake there in the studio, say there are 44 bills that were passed on to him, and some were rejected by the state houses of assembly, some the president overruled them. But then I think that we are not yet there in the area of devolution of powers, balance in the federation, you know, untying those knots that tend to make this country look like it is operating a unitary system. More can still be done, not just in the area of amendment. If you look at the areas that have been assented by the president vis-a-vis the lists in the exclusive legislative list, you understand that it is a far cry from what should be. A lot of those items on those lists are not supposed to be there in the first place. They should be devolved to the states. But we may be thinking about along the line of a futuristic purpose of a wholesome constitutional making, or even if it is amendment, but one that is very overhauling and very that will turn the state of things around for us. But from now, I won't say that it is akin to devolving the powers from the center to the component units. It is still far from it.
Mr. Oguche, for your response. I'd like to go to Professor Dakas now. I'd like you to give us the specifics. We've mentioned 16. Yes, we talked about the fact that financial autonomy for houses of assembly and then the judiciary. We also know about the 60 days limit for president-elect and governors-elect to nominate ministers and commissioners in different cases, and some other. So please, could you just let us know specifically now the 16 bills we're talking about that have been assented to and how they would actually improve the development of the nation.
Okay, thank you. As I pointed out earlier, the ones that, in my view, are very significant are the ones that I mentioned that have implications for devolution. But as you have just alluded to, one of the bills actually is significant because it prescribes a 60-day time frame within which the president and the governors are obligated to nominate ministers and commissioners for confirmation by the Senate and by the state houses of assembly. Now, this is significant because when President Buhari came in 2015, it took about 6 months before he constituted his exco. I think in Osun State, under Arebeshola, I think it took about 24 months before the exco was constituted. So that, I think, informed the decision of the National Assembly to pass that bill, and I'm glad that Mr. President has assented to that. But the other bills are actually bills that have to do with changes of names of some local governments, correction of the definition of the Federal Capital Territory, and so on and so forth. But the ones that I've mentioned are the ones that I think are very significant. Now, to also put that in context, one of the bills passed by the National Assembly, which would have had profound implications for our federal structure, is actually the bills. There were two bills, one on the administrative autonomy of local governments, and the second on the financial autonomy of the local governments. Now, in terms of administrative autonomy, the bill seeks to address a situation where some governors simply dissolve democratically elected local government councils. And the bill would have provided, reinforcing Section 7 of the Nigerian Constitution, that it is not only unconstitutional, but that any such contraption, in other words, the so-called either caretaker committees, would not benefit from any funding from the Federation account. And you know that without funding from the Federation account, very few local governments or states would have any viability. Now, in terms of financial autonomy, you know there is Section 162 that makes provision for a state joint local government account that is often the subject of considerable abuse in some states. And so the bill on the financial autonomy of the local governments would have provided for a scenario in which whatever is due to the local governments from the Federation account would go directly to the local governments. That would have been beautiful. It is yet to be to get the necessary concurrence at the level of the State Houses of Assembly. But as beautiful as it would be, it also would invariably have required institutionalizing accountability mechanisms at the level of the local governments. Because it's one thing to send money directly to the local governments, it's another thing for the money to be used for the purpose for which it's intended. So these are some of the issues that have come up. But let me just make this point very quickly, especially because of the intervention by our colleague Oguche, in terms of the devolution question. Something unprecedented in the alteration of the Nigerian Constitution took place this cycle. When the National Assembly transmitted those bills to the states, and as the states began to vote and began to make returns to the National Assembly, at some point, under the auspices of the Conference of Speakers, the State Houses of Assembly said, hey, wait a minute. We think that there are a number of bills that are significant that the National Assembly needs to pass. And they then wrote to the National Assembly and said, we need you to pass bills on A, B, C, D before we continue with further consideration. And among the issues that they raised, significantly, one is the subject of state policing. Indeed, there were four issues. The first, state policing. The second, institutionalization of legislative bureaucracy in the Constitution. The third, to reinforce the framework for the removal of principal officers of the State Houses of Assembly. And the fourth was a proposal for a State Judicial Council. Now, if the proposal for the State Judicial Council were to be passed, it means that you would not have the concentration of power that you have in the National Judicial Council. That, again, is a very controversial matter, given the history of how the National Judicial Council came into being. But the subject of state policing is something about which very many Nigerians are very passionate and will invariably have profound implications for devolution of powers. So the National Assembly leadership, especially the leadership responsible for constitutional alteration, you would recall, by convention, the Deputy Senate President and the Speaker of the House of Deputy Speaker of the House of Representatives are the lead people in the National Assembly in the context of constitutional alteration. And they then addressed a press conference and said, hey, what is happening? It would appear that the states are being held hostage by their state legislatures are being held hostage by their chief executives. And there was a back and forth. I think that it's a matter that hopefully will be resolved, and before the expiration of the tenure of the 9th Assembly, because if this is not resolved, you move to the 10th Assembly, everything will have to start all over again. So I thought we should put that in context to give you a sense of the tensions at play when it comes to the subject of devolution.
Well, Professor Dakas, thank you very much. Gentlemen, let's look at the issues relating to the alteration now, that the president should have his cabinet within 60 days of his being sworn in, and that the governor of a state should also have his cabinet, that's commissioners, within 60 days of his being sworn in. During the Second Republic, we all remember, in 1981, Balarabe Musa, who was then governor of Old Kaduna State, many say was just the alibi required, but he was impeached by the Kaduna State House of Assembly because they said that he didn't have a cabinet, he didn't have his commissioners. I am wondering, gentlemen, why the necessity for this provision now in our constitution mandating the president or the governor to have his cabinet? Because if you look at the many provisions around the office of the president or the office of a governor, none of them is required to operate solo. So the so-called emperor syndrome that we have seen in the states means that, look, there's no governor who can function without a cabinet or who should function without a cabinet. But as we have said, some state governors have gone on for months on end without having commissioners. Some, of course, if you can hire, you can also fire. But there is a mandatory requirement that you cannot function alone. So I'm going to Festus Oguche before I come back to the speaker, former speaker of the Kogi State House of Assembly. What was this attitude all about? So that the governor just felt that if I can hire you, I can dismiss you. If I can hire you, then I can also choose not to hire any person, and then just carry on. Chief.
Because simply that the presidential system of government which we enabled as our form of democratic experience is one that arrogates so much power to the executives, both at the center and in the component units. So much power that they talk should not even be constituting a cabinet or doing anything in the manner of having commissioners in place. What's the function? What's the functional attribute of those commissioners? A lot of them are there just sitting down without doing anything, knowing anything that's going around their ministries. Same also at the federal level. The issue is quite problematic though, and it's simply that there hasn't been much curtailment to the exercise of political power, constitutional power by the governors, by Mr. President, that anything goes. So much power is arrogated to them, and they exercise it with impunity, so much so that in the states, the governors decide who gets what, who goes where, who knows what, you know, to the extent that like you mentioned the issue of local government and how they are appendages of the state executive, the judiciary itself, the houses of assembly, and these are some of the gaps and the inadequacies in our constitutional process that need to be looked at. Making provision for them is completely unnecessary, because as soon as you are sworn into office, the first thing you do is to constitute a cabinet. Failure to do that will attract the proceedings that could be used against you for impeachment, for any other thing, like you mentioned the case of Balarabe Musa in Kaduna State. A lot of these amendments, well, even though they are well thought out, but I don't think it's totally necessary. It's something that can be left to the state houses of assembly, and even if it is something that should be in a legislation, then the houses of assembly can make a law to that effect regarding the necessity or the need for the governors to submit the names of persons nominated as commissioners or within that state, and maybe for regulating the first session and the inauguration of the members of the Houses of Assembly of states. We are talking about better federalism, true federalism, and I guess that some of these powers can be pushed to the states, while the federal, the National Assembly can handle those ones that pertain to the federation. And I think that's a very good way of going about it.
So we'll go to the former Speaker of the Kogi State House of Assembly, now Honorable Bello Abdullahi. You've heard Professor and Festus Oguche in Port Harcourt, but I still want to ask you about, the House of Assembly, because, I know that you were a one-time active governor in that state, and then being a Speaker of the House of Assembly. I want you to tell us the importance of, this bill, that the President has assented to, granting financial autonomy to the House of Assembly. And then there's a particular bill that did not get the signature of the President, and that's giving the National Assembly and the State Houses of Assembly the power to be able to summon either the President or the governors, of the 36 states. So could you tell us, what is the implication of these two, the one that was signed and what has been signed in governance as far as the states are concerned?
Thank you. Before going to your question, I'm between two very, sound and erudite scholars. Mr. Oguche from outside the station is a constitutional lawyer, and I have my senior Sikh here, who is a constitutional lawyer too. But most time when I meet scholars like this, I learn from them, and I at times disagree with them. Our, man from outside the station mentioned the issue of true federalism, and I always attack any such issues about the issue of true federalism. In the classrooms where they taught us, they will talk of true federalism, but in practice, there's nothing like true federalism. What we have is comparative federalism. Now, coming to your question, financial autonomy to states House of Assembly is a good one, if at all it can be implemented at the state level. The same state assembly that give concurrence to financial autonomy will be the same institution that will undermine that constitutional provision. What do I mean? There are some states today that enjoy almost full autonomy, but just some few states, 1, 2, 3 of them before this constitutional provision. But how has that affected their workability? I mean, the working of the state assembly in those states to effect good governance. That is the issue. Now that by law or under the constitution we have gotten financial autonomy, I'm still very skeptical whether it will function, whether it will work out, whether it will be implemented, because of the attitude, the mindset of those in governance. When we speak about the issue of executives not appointing, constituting their, either commissioners or ministers on time, it is based on attitude. Corruption is corruption, whether financial corruption, social corruption, administrative corruption. When you refuse to do what is correct, the right thing to do at the right time, that is corruption. So people just tend, in this country, we look at corruption as when you steal money or when you, inflate contract. As a governor, if you refused or you delay in, constituting your ESCO, that's corruption at state level or at national level. And my senior Sikh here mentioned, or you mentioned the Barry Musa experience in Kaduna. That was when the state assembly was state assembly. That was when we have very, very competent people at the state assembly level that can look the governor in his own face and tell him that this is the way. In fact, for almost many years back now, till now, I have not seen any state assembly in the country that has, faced their governor and said, this is the truth, this is the constitution, this is the law, this is constitutionalism. And this is where we deviated. This is where the parliament, the state parliament, deviated. They don't even understand the basic tenets of constitutionalism. Those who are the state assembly that were given this autonomy, may God Almighty give us the life to witness the implementation of the autonomy. Because if you don't understand what you are given, if you don't even understand what the function of the constitution, the meaning of constitution and constitutionalism, how will you even know that you have power to enjoy what the law gives you? Take for instance, before the issue of financial autonomy to the state legislature, how many times have we seen on national television of any state assembly on oversight on what they have approved, the appropriation that they have approved for a year to be implemented by the state executive? Do we see any state assembly going on site to look at the roads awarded anywhere in the country? I have not seen for almost 2 times now, since 2015, 2019, or 2011 to 2015. In fact, the nearest was 2011 downwards that we see state assembly on oversight at state level. We've not. Those who did not even understand the power that they have to checkmate the governor, the power you give them now, let's hope that they'll be able to implement, to even know that they have that power. So we need a lot of input from the people. It's like we have left our duty as a people that's supposed to participate in governance outside the legislative and the executive arm of governance. You see, before democracy, we have Nigerian people who are so passionate about freedom, about democratic governance, and they were on the toes, or they're on the neck of the then military administrators to ensure that they give us democracy. But soon that we got democracy in 1999, we all went to sleep. We need to revive campaign for good governance in this country. We need to put in structure, measure, to ensure that we move from state to state to measure governance, either at the state, at the parliamentary level, at the state level, or even the executive, where we believe that the minimum standard is being, abused. We need the people need to rise up to defend democracy. It's not only when elections are held and some people's candidates did not win that we begin to see demonstration on the street. We should demonstrate where good governance is being abused in this country.
All right, Right Honorable, thank you very much. You raised a number of issues, but I want to come back to Professor Dakas. Professor Dakas, let's deal very quickly with this aspect that Right Honorable has talked about. In the course of consulting for the House of Reps for this amendment, what was the intendment of the lawmakers in granting financial autonomy, say, to the State House of Assembly? Because the concerns that Right Honorable Bello Abdullahi has raised, those concerns are quite significant. It likens it almost to handing a Rolls Royce to somebody who doesn't know how to drive.
Well, first, again, let's put this in context. And very quickly, I think we also need to put the Balarabe Musa experience in context, because it's something about which I have researched and written. The challenge that Balarabe Musa had was that you recall that in the Second Republic, you had the National Party of Nigeria, which was the dominant party in the country. But in 2 states, Kaduna and Kano, we had the People's Redemption Party, the PRP. Part of the challenge that Balarabe Musa had was that he was elected governor on the platform of the PRP, but he had a House of Assembly dominated by the NPN. And the irony is that he would send nominees to the House, they would send it back to him, he would send another one, he would send it back to him, and there was a stalemate. And then ultimately it led to his removal. So I think we need to understand that context. Now, regarding financial autonomy, the Right Honorable has given us the context based on his experience. But perhaps it is principally because of that experience that you largely have state houses of assembly that, for many people, rightly or wrongly, are seen as appendages of the executive. They are seen as being held captive by the executive. But part of the reason is because of the lack of financial autonomy. As a matter of fact, to give you a sense of the predicament of the state houses of assembly, before now, an earlier bill for financial autonomy of the state houses of assembly was passed, but did not even get the concurrence of the 24 houses of assembly minimum. So this was a bill that was in their own interest, but they couldn't even get the concurrence. So, and for many people, they interpreted that as a reflection of the overbearing influence of the executive governors on the state houses of assembly. But the expectation is that you need to strengthen governance at that level. And one of the ways through which you can strengthen governance is actually to provide for the financial autonomy of the state houses of assembly. So in principle, again, we wait to see how this plays out in practice. But in principle, it should strengthen them. And then they will be able, hopefully, to overcome accusations that they have not just become appendages of the executive, but that they have become rubber stamp. And I think that with financial autonomy, that hopefully will be addressed. But keep in mind also that power intoxicates, and absolute power intoxicates absolutely. That's my own version of power corrupts, and absolute power corrupts absolutely. To whom much is given, the responsibility that comes with financial autonomy should also not be abused. Because if it then puts the state houses of assembly on coalition course that is avoidable with the state governors, that then leads to impeachment after impeachment, then again we're going to have a constitutional crisis. So for me, it's a welcome development, but it is power that needs to be used responsibly.
All right, powers that should be used responsibly. So much powers have been given to states with this assent, the 16 alterations. And my question now is directed to Festus Oguche, talking about the power given to states to be able to generate, transmit, and distribute electricity in areas covered by the national grid. And then moving railway from the exclusive list to the concurrent list. So of course states now have the power to do whatever it is they want to do in those sectors. Do you think that the states are actually responsible enough for Nigerians to see improvement in these sectors? Do you, first of all, my question is directed to you. I mean, all the things that are on the concurrent list, the states have not even been able to deliver on those items, and now they have an addition: electricity, railway. Do you really think that the states, talking about the governors now and then, governance in states, we're likely going to see an improvement in these sectors and probably get much more better development?
It's not that the governors lack the capacity to deliver if those items are within them. A lot of those items, like I said earlier, in the exclusive legislative list actually should belong to either the concurrent lists, and we don't have a residual list. But then the states legislature and the governors are bereft of a lot of those items. Even in the concurrent list, there's this tendency of the national legislature to close in on some of those areas and sort of shove the state assemblies aside by the constitutional principle of meeting the needs of the people. So to a large extent, I think what you should talk about is not responsibility of the states, but the capacity of the states. It is not an easy thing to run, to generate, transmit, and distribute electricity. I've been in Port Harcourt here for quite some time, and I remember that in the days of Peter Dili, there was that attempt to electrify the state properly, and this thing was frustrated with a lot of hiccups here and there, administrative hiccups, and a lot of states are ready to do that, so that this thing should not be concentrated in the federal power, within the spheres of the federal power. Incidentally, the thing could not see the light of day because of a lot of politicking that came in. I believe that states, they have that capacity, if given to them, to do more. I think it's even the lack of capacity that makes some of them behave like monsters, and they sort of, permit my word, and some of them act like demigods, and that they subdue and subjugate anything they see, from the houses of assembly to the local governments, in spite of the constitutional guarantees for their autonomy and independence. If you talk about the railways, I think it's another good area where I commend Mr. President a lot for taking that bold step. I know that railways usually, most mostly, even in the United States, in UK, they are always allocated to the center because they involve cross-border, cross-component unit, cross-state dimensions and all that. But recently, we announced railways developed within cities, and the distance to be covered doesn't even matter anymore. But then putting it in a concurrent list will also involve a lot of commitment on the part of the governors of the states to ensure that it is not abused. The area of development in the railways, specifically with Nigeria, has not improved quite well up till more recent times, unlike the earlier days when trains can traverse from Lagos all the way to Kano and Maiduguri and all over the place. We have not improved in that aspect, and I think giving this aspect to the states will involve a lot of financial implications, except we are talking about the kind of railways of the type that we have in Port Harcourt here, built by Amechi, which is only about 2 kilometers. But if it is the wider dimension of railway services, I think, why not impugnate the effects of the amendment? I think it's something that the federal government should take the bull by the horns for now, or to get developed to that stage where now the states or even the local governments can now talk about investing in railways within their domains. I think largely these amendments are very welcome, specifically the one about electricity generation, about the railways. Those are touching on very serious areas that pertain to livelihood, to the good living the good life for Nigerians, and ensuring that people get the bounties of good governance and democracy in our system.
All right, thank you very much, Chief Festus Oguche, for your intervention. I want to come back to Right Honorable Bello Abdullahi. Well, you are expressing some concern about the powers that state legislatures would not have, having now been vested with financial autonomy. But we have seen at the national level, National Assembly operating without a great deal of friction with the executive. That's to say, in terms of this relative financial independence. Where are we moving away from, and where are we going now in terms of financial independence for the state legislatures? And how do we, therefore, in moving away, avoid the syndrome that Professor Dakas referred to of power corrupting absolutely? You may well now have speakers who may turn out to be small emperors, since the bigger emperor is the governor. Or how do we avoid that?
Well, I don't think we have seen Senate presidents and the speakers of the various speakers of the National Assembly as emperors at the federal level. Rather, the financial autonomy that was practiced and effectively put in place at national level has impacted on the effective functions of the National Assembly. It was not just gotten on a platter of gold. They fought and got it. And in addition, that we have very highly quality people at national level, as senators or House of Rep member. It is not the same thing at state level. Even at state level, that we have some few states where we have highly educated members as members of state as parliament. They are still caged by the governors in every term that we set up the state assembly. I have this belief that just like what Prof mentioned, or what he mentioned about the issue of when the previous amendment that the state legislators denied themselves financial autonomy. It was even far than that. Than the third alteration of the Constitution, we had 24 states putting concurrence to the alteration for financial autonomy. Going to the Senate, one state from the north, I can't recall which of the state, either Katsina or Zamfara, but my mind was on Katsina speaker or Zamfara Speaker, went to the Senate chamber to withdraw yes for financial autonomy and replace it with no. At that alteration, we lost it. So you can imagine at the third alteration of the national of the constitution, if the state assembly can go as far, be mobilized by its governor to go to the Senate. The Senate was already considering the alteration, the concurrence. Only for them, there's no, from my state, I now want to replace my yes with no.
Well, we have no information that they were mobilized by the governor, but it's also the prerogative of the state legislature to say, I don't longer say yes, I want to say no. Isn't it?
You see, well, let me tell you, because we are talking of issue of practice now. We are talking of issue of practice. You saw when we made, Kogi State was the first state to say yes to those alterations at that time. And when my governor came from overseas trip and he saw what we have done, he called us and said, look, you're all joking. This thing will not go through. They will find a state that will say no. And they were able to do it. So that is the mindset. That is what is still prevailing up to today. You can imagine at the present time that governors will transmit letter to the state parliament to take certain action that is unconstitutional, and they do go ahead to do it. Even though such transmission of information or directive has no basis within our law, and what the speakers or the state assembly is doing, it's not having anything within the law, and yet they are carried out with impunity. So I'm still in doubt whether this, yes, of course, in law, in the constitution, it is there. I'm happy that it is there. We will continue to ensure that we monitor the effective implementation of this financial autonomy. And the issue of the speakers becoming emperor, I don't think it will happen. In fact, the lacuna that is left in this alteration as regards financial autonomy is that we have given financial autonomy to state legislators. At what percentage? What are we giving them per year from the state budget? Because the reason why the 13th derivation paid to Oyo State is because it's in the constitution that it must be 13% of the budget, of whatever coming.
Not less than.
Not less than, but it can be more. But if we just give, say, autonomy, to say I give autonomy to my senior Sikh here, without specifying what manner of autonomy, what am I going to give him, there is still a lacuna there that will be abused over time.
Okay.
Which raises the question, I believe, Prof, I was asking earlier about the intendment of the framers of this alteration to say the National Assembly has its own budget. And of course, it also passes its budget and it goes to the executive for accent or for the president to veto the bill that has been passed. But we know that in recent years, there have been back-channel communication activities involving the legislature. Isn't that possible to activate rather than everything being on the table front out and then confrontation and saying, no, this is our legislative power, you are executive, this is how much we are entitled to. How much you will be entitled to as a lawmaker, if I say entitled in terms of a financial autonomy, will depend also on the financial health of the state.
Yes, coming to your, what you have raised now, don't you know that in some few years back now, just a year or 2 or 3 now, the National Assembly was starved of funding, even though their budget was approved, but the executive refused to release the money to them. They had to cry out that they don't have money to even implement the commonest thing to do in the National Parliament. So this is what we are saying, that it will happen at state level, where the state assembly even attempts to put into practice the autonomy. The governors may say, okay, there's no money, because there's no specification as to what is accrued to them. Even local government that has what is accrued to them is being mismanaged through a joint account. So we still have a lacuna on this alteration that the senior lawyers here need to. Since you are a consultant to the National Assembly, I think you need to consult well with them and tell them that, look, we may need further alteration to ensure
Can I just say on that point?
Yes.
Actually, when you look at the specifics of the bill that has been passed and assented to by Mr. President, the mechanism for dealing with all these issues is set out there. And as you rightly pointed out, you also have to be conscious of the constraints of the budgeting system. But there are specific proposals that are set out there about how to determine what is due to the judiciary, what is due to the legislature, and what is due to the executive. When those mechanisms are put into practice, hopefully they will achieve the desired goals, because the intentment is essentially to strengthen the mechanism of governance at that level. But the Constitution is a living document. And as developments unfold, and if we see that there are any lacuna, of course, I believe that the National Assembly will be more than delighted to take a second look at it.
All right.
Yeah, just I know you were going on a short break now. I hope that the lawmakers will not, at some point now, be demanding to have their own accountant general. Or the judiciary will not be saying we must have our own accountant general. Because the money normally will be released through the office of the accountant general, who is under the commissioner of finance. Because when you say there's no money, the governor will not tell you directly there's no money. The business, the key to the treasury is held by the accountant general of a state. So we hope that you don't create another bureaucracy and say the State House of Assembly should have its own accountant general.
Well,
Right.
I just hope, again, there are mechanisms of checks and balances. I alluded to the risk of the abuse of power. But where, for instance, there is money appropriated for the legislature and the money is not released, and there is evidence that the money is otherwise available, there are mechanisms that can be put in place. He knows. They would know how to hold the executive accountable in that context.
All right. I think we've dealt so much on the legislature. We'll talk about the judiciary, but that will be after this break. Please stay with us.
Everywhere you go, from banks to hospitals to public offices, mass transit stations, airports, and even telecommunication centers, senior citizens are treated as nuisances. They are not. They are senior members of our society, and they deserve the utmost respect. We shouldn't be having our aged fathers and mothers standing in long queues to withdraw their monies at banks. Our retired senior citizens shouldn't be caught standing in buses for lack of seats or chasing after one just to get to their destination. Senior citizens shouldn't have to sit long hours in hospital corridors with no geriatric specialist to attend to them. Our senior citizens deserve better treatment from all of us. They deserve to be listened to. They are deserving of seat reservations on public buses and priority attendance in public spaces. As young people, we are quick to say, no one owes you. This is not true. We owe the elderly members of our society a helping hand, our services, and respect. Age-friendly societies have more senior citizens enjoying good health, living safely, and engaging in meaningful community work than those who do not. Dignifying age-friendly services for senior citizens.
The counsel of our fathers.
My advice to these young people is please do not take us back to those harrowing days. You probably do not know what it is.
Nigerian youths, let's build our nation together.
All I need to say about the second River Niger Bridge, 21 years ago, as I came onto this throne, it will normally take you 3 to 4 hours to cross the bridge. I mean, if you are going to Lagos, you spent almost half your time on the bridge. And you were stuck on the bridge before you came across from Asaba this morning. Now, could you imagine how the people of Onitsha and Asaba have endured such a situation for over 25, 30 years? This is reality. So we cannot overestimate the importance of the second River Niger Bridge. To express appreciation to our President, Muhammad Buhari, for being the vehicle for the execution of this monumental project.
All right, welcome back. You're still watching Good Morning Nigeria live on the network service of the NTA, and we'll still have our guest with us right here in the studio, and of course Festus Oguche, who joins us from Port Harcourt. We're talking about the alterations done to the Constitution. And before we went on that break, we dealt on somewhat some of the issues, and I would like Prof to talk about the judiciary, because for Honorable, who was a speaker, he feels that for the House of Assembly, which is getting autonomy now, financial autonomy, they may still just be an organ of government that may just be able to back and not still be able to bite. But for the judiciary, now that they're going to get financial autonomy, what does that portend, for that sector and for governance in general in states?
I recall that as students in the university several decades ago, one of the things that struck me in the course of our constitutional law class was, and it's a very interesting expression, that the judiciary would go cap in hand to the executive. And I found that very striking, and it has stayed with me over the course of time. And my point essentially is that the subject of financial autonomy for the judiciary is long overdue. And yes, the judiciary is a separate arm of government, but where you have to go cap in hand to the executive in respect of virtually everything, that itself undermines the independence of the judiciary. And as you know, the judiciary is a very critical component of the tripod. And one of the things that actually played out was JUSUN, the Judiciary Staff Union, went on strike and eventually went to court and got an order of court on financial autonomy. And so what this amendment does is to strengthen that framework. The expectation is that the judges will be more independent. The judges will pronounce on issues that will strengthen our democratic experience. But again, I'd like to underscore the point that Honorable Bello made at the level of the state legislature. It's one thing to grant financial autonomy to the state judiciaries, but there is also the need for the judges to exercise their responsibilities with consideration for the dynamics of power relations, but more importantly, to inspire confidence in Nigerians. There's a common saying that the judiciary is the last hope of the common man. But increasingly, many people are worried about some of the judgments that are churned out from the judiciary. And I hope that to whom much is given, much is expected, and that our judges will rise to the occasion, and that this will be implemented effectively, so that we no longer have that really sad situation where judges would have to go cap in hand to the executive.
Well, just before we go over back to Festus Oguche in Port Harcourt, I want to just throw in this one, because it was one of the bills that the president vetoed. And that was a bill that was seeking to empower the legislature to summon the president or the governor. I was wondering whether that wasn't some surplusage, because the legislature already has the powers to invite any person. So what then was the intendment in engrafting it in the Constitution to say we have powers to summon you? And we have also seen, I say this with the greatest respect to lawmakers, sometimes the flagrant abuse of the power of summons. You will summon one minister, today, before the minister gets to his or her office, you summon the minister back again. One committee will summon, another committee will summon, subcommittee will summon, a commissioner will be summoned. You just, so that people just didn't have any other thing else to do except to be answering to the summonses coming from the legislature. Was the president not right in... yeah, Professor Dakas, you want to intervene before?
Yes, I want to provide context.
Yes.
You used two terms that mean two different things. The power that currently exists in the Constitution is the power to invite. Now, what that bill sought to do was to summon. And there was, frankly, a great deal of controversy over whether this was not a constitutional overreach. Because the president does not have power to summon members of the National Assembly. He does not, under the law. He cannot summon the National Assembly. And in the course of deliberations over that bill, very many of the contributors expressed apprehension about whether this was not a constitutional overreach. To now say you're going to summon the president or that you're going to summon the governor. You can invite them, but to say that you're going to summon them clearly raised fundamental questions about the prospect of a constitutional overreach. I think that is important. That does not deviate from the concerns that you have raised about even the possible abuse of the power of invitation. But I think that perhaps this is one area that one might well think that Mr. President acted correctly. Because to then wake up and say, oh, you are summoning the president. And then if the president then says, all right, I summon members of the National Assembly, you can imagine
cross summonses.
I'm actually not aware, and I stand to be corrected, I'm not aware of any constitutional democracy, I may be wrong, but I'm not aware, where the legislature summons the executive or the executive summons the legislature. I don't think so.
I think giving credence to my learned sick here, that power of someone is very strange to the principles of constitutionalism. And but invitation, yes, but to someone, I don't believe is the most appropriate, way to go. Before now, there's no state legislature or national assembly that cannot invite the executive to appear. The power to investigate also give by the state legislature also come with the power of invitation or even arrest. Mm-hmm. But that does not include the executive, to arrest the executive of a state because of you invited him or because of any infraction. But we can invite the governor of the state, we can invite the deputy governor of the state and any functionaries of the government of any state to appear before a committee or the committee of the whole to explain certain things to us. But you see, because of collaborative nature of governance, all these issues are sorted out even behind the scene. What I mean is that if, from my experience, if we notice that the state's policy is arcane, is negative, too harsh on the people, we can invite that agency that presents the executive to appear before the parliament, the state legislature, to clarify certain things. We have an example in Kogi State in around 2011 or thereabout, where the state governor then set up a panel to audit the state workforce. And right on the field, the head of that auditing panel was sharing certificates of citizens, throwing them on their faces. And when it got to us, and it was read on the floor of the assembly, we now invited the head of that auditing firm to appear before the state legislature to explain to us why they decided to treat our citizens in that manner. And the lady, I believe, who was the head then, refused to appear before us. What we did was to write to the State Commissioner of Police to arrest that person and bring her before us, only for her to run to the governor that she's been, the police is about arresting her. And the governor invited us to question, to question us why do we order the commissioner to arrest the woman. And we now told the governor that we have the power to invite, to direct the police to arrest such. And we sorted it out. We now told the governor that except this woman leaves Kogi State territory by tomorrow morning, the police will have to arrest that woman and bring her before us. And the woman disappeared since that time till now.
Now that's my question, Prof. We're talking about invitation and summons. There are two different words. When you invite someone, the person can decide whether to honor your invitation or not. Mm-hmm. All right. Now, we're talking about the House of Assembly, and we're saying that the president has done well by giving them financial autonomy, which means, well, they should be independent of the governor. Now, these people in the House of Assembly represent the people of that particular state. Mm-hmm. So it's like saying the people of the state calling the governor, who they put in power, to probably, ask him about certain things or, for him to clarify certain issues. So when you give the House of Assembly the power to summon, He means that, you know, whoever you're summoning cannot decline. It's not an invitation. An invitation is open. You can say, oh, well, I'd like you to educate me, because for me, I'm just looking at the two words and what they mean.
Yeah.
If you invite someone, he could just decide to tell you, you know, I may not want to honor your invitation, and there's nothing you can do about it. And we have also said that you cannot also arrest the governor. So, but for someone, when you have that power to say, well, you have to appear on a certain date, then you cannot decline.
Yes.
Isn't that giving power to the people and, you know, having the governors in check?
Yeah, the intention, first, the power of invitation is a power generally that you can extend to the governor or to the president. But in terms of the power to summon, the House of Assembly, the National Assembly have summons powers, but not in relation to the president or the governor. These are two different things. The House of Assembly, for instance, as Honorable Bello has pointed out, can summon a commissioner, can summon some head of agency. But to summon the governor, no. It's the power of invitation. And this is a function of the separation of powers. Like I said, the flip side is that the president cannot wake up and summon any member of the National Assembly. But you can invite them. So that's why I raised the issue of a potential constitutional overreach when you are dealing with the head of the executive or you're dealing with members of the National Assembly themselves in terms of summons. So yes, there's the power of invitation. First, even in relation to functionaries that are not the heads of the executive, you can invite them. That's a courtesy. But if you decline the invitation, they have recourse to the power of summons. They have that. But the point we're simply making is that what this bill sought to do was to now empower the legislative arm of government to summon the head of the executive. And we're saying that is a potential constitutional overreach.
All right, Professor Dakas, thanks. Chief Oguche, sorry we've kept you slightly idling while this conversation was going on. You may wish to weigh in on some of the aspects, but one I want to raise very quickly, because it's been a matter that we've dealt with on Good Morning Nigeria, and we are all familiar with the congestion in our prisons, now known as Correctional Center. Of course, the Prisons Act itself was amended, but the shift from the exclusive to the concurrent list, many would say, is significant. Now, this is not novel in our jurisdiction. Under the fifth alterations, it may well be so, but in the First Republic, the regions had control over their prisons. And of course, the native authority clearly abused some of their powers and threw people into the dungeon. But we have seen, with fact, growth in population and then also the growth in the number of state offenses and federal offenses, everybody just gets lumped into one correctional center. Now, states have been empowered to also build their prisons. Where is this likely to lead?
Before I answer your question, I have two issues to look at critically. I think it's a matter of semantics between the word summon and the word invitation. But I think the word summons is one that pertains to judicial procedure, and it's a judicial action, and it cannot be attributed to the legislature except in very certain situations that call for it. I know that in the parliamentary system of government, Westminster type of government, the Prime Minister can be invited, failure upon which the legislature can sit and put forward a vote of no confidence against him. So if he doesn't attend the invitation, he knows the implications. But it is not very welcoming to suggest that a president or the governor of a state can be summoned by National Assembly or the State Assembly. That is number one. Now, the second one is the judiciary. Use issues about the financial autonomy of the judiciary, which I think is a very welcome development. There's been some executive orders signed by the president regarding that aspect to ensure that there is some shade of independence on the part of the judicial system. But if you have to do anything with the judiciary, I recommend the amendment that will tend towards totally separating it from the executive interference as much as possible in terms of finance, in terms of appointment, in terms of discipline. That at the federal level, for the federal courts, it's the president that appoints the judges with the recommendation of the NJC, and so at the state levels. And this has brought out a lot of issues that tend to undermine the capacity of the judiciary to be fair and objective in the dispensation of justice. I seriously suggest that the judiciary be insulated completely from the executive arm, from political elites, to ensure that it works and functions in accordance with the dictates of judicial office and in accordance with the expectations of the Constitution, in accordance with the will of the people, to the extent that the expectations of the public will be met by the decisions they give. We've now seen in recent times from the Water and Organ case and the Ayosalami cases that the National Judicial Council can succumb to arm twisting tactics. So those guarantees that are constitutionally provided to ensure that they are not vulnerable to certain extraneous influences are no longer there. All right, now to your question, you asked about the prisons, formerly known prison, now known correctional centers. It's a very good thing. There's something in the name, as much as I understand. And as a matter of fact, these institutions are actually supposed to be correctional in every sense of it, and not to be looked at as places where humans are dehumanized, demeaned, and treated like animals. If the president will make that accent, having done that, I commend him very, very well. We have the prisons that are built by the colonial masters, which are meant for maybe a couple of inmates, a couple of 20, 35 inmates, now having about 200 and 250 inmates in them. And a lot of these prisons are not properly being well taken care of. A lot of the prisoners themselves are not getting enough in terms of feeding. We had the story that one time of how the funds for their feeding has been diverted, and we looked at human beings from the prisons looking like scarecrows and skeletons. As far as I'm concerned, I think it is quite enabling that this aspect of the item in the exclusive list is now in the concurrent list, so that there can be a separation between federal offenders, as you pointed out, Kingsley, and those at the state level. But then it should go beyond just having these names patched on these institutions. It has to go into actually providing the modern facilities that are required to treat prison inmates as human beings, because in so many ways our prison system is totally under operated. It's not just one that one can talk about here, but it's not impressive at all. I know there are certain penal.
Thank you so much, Festus Oguche. Because of time, would actually have to leave the conversation at that point. You know, I actually wanted to ask Prof about fifth alteration number 34. We talked about food, but there's no time. I'm sure tomorrow when the conversation continues, we'll talk about what that is all about, ensuring the right to food and food security in Nigeria. You know, so many issues, you know, that need to be looked at. And of course, the 19 other alterations that were not assented to, we also need to look at them, and if there is need for maybe the 10th Assembly to follow up with those issues. So that will be it for Good Morning Nigeria this morning. Many thanks for joining us on the program. We'd like to thank our guest, Professor Dakas, C.J. Dakas. Many thanks for joining us.
Thank you very much.
Also, Right Honorable Bello Alhaji Abdullahi. Glad to have you again. Festus Oguche in our Port Harcourt studio, we do appreciate you for your insight this morning. Gentlemen, thank you once again. So that's it for Good Morning Nigeria, live on the NTA. I'm Ian Ray John. Enjoy the rest of your day.
Look after yourselves, as I always say. I'm Kingsley Osadolo.